Welcome, my name is Brett Davies. I'm a barrister and solicitor of the High Court of Australia, and I hold a number of professorships around Australia. I specialise in superannuation and tax. Today we're going to look at a self-managed superannuation fund. To start it, you need a deed. So we're going to look at the deed and have a bit of fun building one. While our law firm is the only law firm in Australia which you can prepare legal documents on, every other website begs, borrow or steals from our law firm's template and doesn't have professional indemnity insurance. On our website, you're dealing with a law firm. You ring up the law firm, you're going to speak to lawyers. So all our 380 documents plus are all protected by our law firm's professional indemnity insurance, legal professional privilege and what have you. So I'm going to one of my favourite topics, self-managed super funds. And there are lots of different documents you could build. So we're going to build a self-managed super fund deed, but maybe we'd want to have a company as trustee, in which case you have a special purpose company which you can build on our website. Maybe you've got an old company you don't want anymore, you want to convert to a special purpose company. Now the reason you want a special purpose company is only for one reason, and you pay ASIC fees, yearly ASIC fees, which are far less than what you normally pay for a company. So if you have a special purpose company, you can only use it to be trustee of a self-managed super fund, which is kind of good in my view. I don't think you should have a company doing more than one job. A company can wear more than one hat. So for example, you can be a father, an employee, member of your football club. You can wear many hats as a human being, and so can a company. A company can wear many hats as well. And I think there's an advantage in only having the company, having a special purpose company, just be trustee of the self-managed super fund. So often I see clients, they grab the checkbook to buy a diamond necklace or a pearl necklace for their wife or someone else. And they find a month or 5 months later, they actually bought it out of their self-managed super fund corporate trustee. And you don't want situations like that. It's good to have, in fact, separate bank accounts. So with my self-managed super fund, I have a set of bank accounts, a self-managed super fund in a separate bank to my own private banking. So getting back to self-managed super funds, we have a binding death benefit nomination you can build as a standalone document, but you'll be getting that for free when you build a self-managed super fund deed. You get an investment strategy which you can build by itself, but you also get that in your self-managed super fund. You need a product disclosure statement, but that comes free with a self-managed super fund deed. If you ever want to wind up, invest your self-managed super fund, there's a document for that. There's also this self-managed super fund training course, which is what you're watching at the moment. Then there are loans to third parties, because self-managed super funds can lend money. That's within the powers of a self-managed super fund deed. Now I know self-managed super funds can't lend money back to the members. Maybe they can lend to a related party. They're quite complex issues, but you do need a complying loan agreement, and that loan agreement's designed to satisfy the SIS legislation. Similarly, a self-managed super fund may own property. It may own residential property. It may own commercial property. It's entitled to own pretty much whatever it wants to own, provided it's part of its investment strategy. And if it leases out the property, either if it's business real property, that can actually be leased to a related party, but it has to be very compliant with SIS legislation, and that commercial lease is very compliant and designed. Then you could set up a reversionary pension kit, which we'll come back to a little bit later. After you build your self-managed super fund deed, you'll be happy to know that every 5, 6 or 7 years it needs to be updated. It's a bit like your motor vehicle. A self-managed super fund deed, like a family trust deed, needs to be updated on a reasonably regular basis. And that's in part because your government, your federal government, uses the self-managed super funds as a kind of football between the Labor and Liberal. Also, you will find that big industry super funds made up of left-wing unions and pub owners will put pressure on the government of the day to try and make self-managed super funds look less attractive, because there is money to be made for these industry super funds for you not to have your money in your super, but to have your money in their industry super funds, which is quite disturbing. Some of the political pressure these left-wing trade unions have been putting on to our federal government. So you can actually do a full replacement deed after 5, 6, 7 years, depending on how many changes the federal government's made. And you can actually replace even a lost self-managed super fund deed. You can change the name of your self-managed super fund deed, and you can do a complete update. So you change the members, update the trustees, all the new rules. There's some different documents. No product disclosure statement for your self-managed super fund, wife sues accountant, advisor and husband. When these laws were changed to require a self-managed super fund to have a product disclosure statement, I was the first person in Australia, the first tax lawyer in Australia to say you must have a product disclosure statement. Everyone disagreed. Oh, no, you don't need. Professor Davies is being overcautious. You don't need a product disclosure statement. But I'll tell you why you needed one, and I'll tell you why all those accountants, financial advisors and tax and superannuation lawyers came on board. It took them a few years, but came on board. You don't need a product disclosure statement for your self-managed super fund if the members know everything there is to know about a self-managed super fund. But no member has that knowledge, so it's quite common that the wife will end up suing you, the accountant, the financial advisor, tax lawyer, or the husband, because they don't know what's going on. So you need a product disclosure statement, and you will get that for free when you build the self-managed super fund deed. Or everything comes with the self-managed super fund deed. Now, there is more information, plenty of training videos all the way through on each and every question for your self-managed super fund. Most people have a company as trustee of the self-managed super fund. It used to be a debate. Should I have a company as trustee of my self-managed super fund, or should mum and dad be the trustees? So what the law is this. Let's say mum and dad have a self-managed super fund. They can be the trustees of it. And same to the cost setting up a special purpose company. But it's probably better for many reasons, and we'll go through them today, as to why we believe it's better to have a company. But let's assume that you now have a company, and let's start building the self-managed super fund deed. Now, I can pick up data from a previous document I've built, but in this instance, I'm going to merely pick up data from an old document. But in this instance, we're going to start a brand new self-managed super fund with no information. So if you're an accountant, you could, and maybe you've done estate planning on our website for your clients, maybe you've set up a family trust, you could pick up the information there and it will come into here and it'll populate a lot of the document. So not many questions. The fund, the members, the trustee, reference and a summary. So there's not much in a self-managed super fund when you build it, but there's a lot of information you need to know as to what you are actually getting. A self-managed super fund is like a one-day-old baby. It needs constant care and supervision. Let's say you've got a family trust or say a 3-generation testament trust in a will. They're pretty rough and ready type behaviour. You don't have to be squeaky clean with those sorts of things. You can make mistakes and rectify. With a self-managed super fund, you've got to be exact. It gets audited. The ATO are very, very careful to make sure these funds are held for your retirement. If you fail to obey the SIS regulations, you can get taxed up to 50% of the value of your self-managed super fund. So this is a really delicate type of business structure or type of superannuation structure. Let's have a look at the hints here. So requirements to set up a self-managed super fund. So these will take you through the rules of how many people you need. So there are a maximum of 4 members. The government's always threatening to increase that to 6 members of a super fund. But at the moment, the maximum number of people you can have in your super fund, your self-managed super fund, is 4. Where with a retail fund or an industry fund or other types of super funds, you can have an infinite number of members. But with our Australian self-managed super fund, maximum of 4, minimum of 1. So it's just you by yourself, or you and your spouse, and you and a couple of children or some other people can join you. 2 business partners could join you, the 4 of you. I'm not a big believer in that because I think it's for the small cost it costs to keep a self-managed super fund going. I think your business partners should set up their own one. Now, the name of the fund. Well, the name of the self-managed super fund and a family trust for that and a unit trust is a nickname. You can make one up. So I think the most common name of a self-managed super fund is a Smith super fund. Everyone's called Smith's got Smith super fund. My super fund's called the Davies Superannuation Fund. So often you just use your surnames. Don't put the word "the" in front of it. The word "the" is already in the document. Your financial advisor and accountant will have a fit if you start your self-managed super fund with the word "the" because they've got to file them in the filing cabinet. They don't want to file everything under "the," THE. Also, the word "fund" will be automatically put in the trust deed. So I need to delete that, the word "fund." So my super fund is called Smith Super Fund. And the address can be any address you want. So let's make it, say, the home address, which is in Coburg, Victoria. That's the address. Maybe it's your accountant's address, maybe it's your home address, maybe it's your business address. It doesn't make much difference. It's not part of the necessary requirements of compliance with a self-managed super fund. Now that's good. I've got the name of the fund and I've got the address of the fund. I'm getting there. I'm going to press next. Now with the members, I've been told I can have 1, 2, 3 or 4. Professor Davies told me that. If you have one member fund, you'll have to have either a company, being the trustee, or you'll need another person to be a co-trustee with you. And this gets a little bit complex, but our system sets it up. So if you put in only one name, it will force you to have the name of a co-trustee. And that co-trustee does not necessarily need to be a member themselves, but it can't be someone that you employ or that employs you or you employ them, because that would be an unfair balance of power. So generally it would be a child or a friend or what have you. So ASDF, the first member's address is in Riverstone in New South Wales. Now I'm going to, I've got some green ticks. I like that. Whenever you get a green tick, it means that our law firm is satisfied with how you've answered that. Now, we are building this document for you. You will put the data in as a mere scribe, but you're not involved in the legal process of the building of this document. We are. Legal Consolidated, barristers and solicitors carries every single part of the risk of this particular document. So, I'm happy with one member. What's going to happen next? So, all the members are going to be trustees. Aha, there it is. I've only got one member to this fund, which is legal, which is fine. I don't have a company. I've said that all members are trustees, and the system, our law firm's logic flow, which we own and control, has said you need to have a co-trustee. I'm not happy with that. I've actually got a spare company. It's not a special purpose company, but I'm going to use it nonetheless. It doesn't have to be a special purpose company. I will convert it over to a special purpose company another time, and it will be called ASDF Pty Ltd. So that's a company. A company has an ACN, an Australian company number. So all Australian companies must have an ACN. And it's always 9 numbers. Now, if you don't know what an ACN is, well, it stands for Australian Companies Number. Now, what if you don't want a co-trustee? Well, then put in as a company. So the rules are here for you. You want a company as trustee? There's a hint there. Now, there's an argument that maybe you don't want a company, and this gives you a bit of advice as why we think you should have a company. Can you have both the company and yourselves as as trustees of the fund? No, you can't. These are strict creatures of statute. They're not a unit trust or family trust where it's just you can use common law and make up things and do wonderful creations and put things in your trustee, your family trust and unit trust. This is a creature of statute and you must follow the rules to the letter. Otherwise, we will not allow you to build the document. Your accountant will not sign off and your auditor will not sign off and the Australian taxation will be angry. Now, in this instance, I've got a single member fund and I've got one company as trustee that complies. So, I've now got everything I need for a self-managed super fund. I've got 3 green ticks, which means that I am ready to build this document. We have accountants that have done hundreds of documents on our website and they'll put in a file reference here. Otherwise, if you're a mum and dad, leave it as a self-managed super fund. If you are an accountant, financial advisor or lawyer using our website, then you can change that to your reference number so that in years to come you can log back into our website and pull off the 3-generational testamentary trust and will or the family trust or the self-managed super fund or the company, whatever you've been building for that particular client. Most accountants and advisors will want their logo to also be on the document next to ours. You can remove the legal consolidated logo from the deed, but you should not unless you're a lawyer. Our law firm's building this document. You want to cling to the bosom of the law firm's protection, so you don't want to remove the legal consolidated logo unless you're a lawyer. You can select that box if you want our lawyers to prepare up and post to the documents. I don't, I can just print that off myself. And if you want one of the lawyers to actually telephone you to go through the document, then just put your name and address here, name and telephone number, and one of our lawyers will ring you straight away. We've done it. We've built ourselves a self-managed super fund. We've got another child, another mouth to feed to the family. So I'm now going to press next. And this is the summary page. This gives us an opportunity just to check the spelling. Have I got capitals in my name and what have you? Now, I realise that I now want to change that. I would like my wife to be a co-member. So I'm just going to go back to the membership and I'm going to add another member. And this time I'm going to put my wife's name in. And that's it. Just 2 members are fine. So I'm going to go back to the summary page, have a look. I'm happy with all of that. Now I'm going to go to, well, no green ticks. What's happened? That's because we want you to check the logic flow again. So let's have a look. We're now happy. We've now checked the logic flow. Our system has checked the logic flow and we're now happy. And something has happened. The lock and build button appears. Now, if you don't see the lock and build button, we're not happy. You cannot build the document until your lawyer, we are your lawyers, are happy. Now we're happy. We've got the lock and build button. So I will now put in my credit card details. And within a few seconds, the document has been built by our system. It's been emailed to you and you can now access it directly from your documents, and you can do that you can come back in 20 years time and there will be the document you built back 20 years ago. So all our documents are stored and all the data that you've put in is stored. So if you want to build another document in years to come, you pick up the data from that. So there's my self-managed super fund. It's got 2 documents, the self-managed super fund deed and the self-managed super fund investment strategy. So let's have a look at the first one. This is a locked PDF. Why is it locked? You're asking why it's locked. It's locked so you can't change it. If you need to change it, there's a spelling error or something, just email us or send you a voucher to update the document. You cannot change it. It's a locked PDF because your lawyer prepared it and we don't want you fiddling with it. If you need to change it or you want to discuss anything, telephone one of our superannuation lawyers. Or telephone me. So there it is. It's on legal consolidated letterhead. This is a covering letter. How to print it. Don't print it back to back. All the clauses it's got. Reversionary pensions. Now, at death, when you die, because your superannuation's for your retirement, now you're dead, the super has to be paid out. One exception to that is a reversionary pension. So if you've got a spouse or a child under 18 or even a 25, someone under 25 that's one of your children still at home, you can set up reversionary pensions, which allows the money to remain in the super fund a bit longer. That's a financial planning product. You need to talk to your financial advisor about that. So there's the covering letter. Minutes. What's a minute? Why is there a minute? A minute is merely an acknowledgement of what you have done. It doesn't do anything in itself, it just acknowledges. So here is a minute, which will be required by the auditor, and this will be kept by your accountant in their due diligence file for this self-managed super fund. And it just acknowledges that the trustees have power to act as trustee. In this case, you've got a company. And no trustee is disqualified under the SIS regulations. For example, a bankrupt person is disqualified from being a trustee. A person that's living overseas may have problems with that because you've got to have central management control back in Australia. So you need a majority of trustees being in Australia. And that's signed by the parties. So that's the first minute to accept the trust deed. Now, the next minute is accepting the new trustee or resignation of an outgoing trustee. So over time, if it's the case a trustee is going in or out, that's the minute that you will need. And it tells you what you need to do at the ATO's website. So you'll just keep that with the trust deed. And here's the start of the self-managed super fund trustee prepared by Legal Consolidated, who are specialists in this area. I've been practicing personally in superannuation since 1988, and while the law firm Legal Consolidated has a lot of skill sets in different areas, this is my baby. This is one of the areas that I manage in this particular law firm. So, the trustee is the company. There's all the definitions. Members. Now the SIS legislation is many different regulations and acts. This self-managed super fund deed complies with all of them, but it is a permissive deed. Now what do I mean by that? There are two types of self-managed super fund deeds, regimented and permissive. Now back when I started in 1988, what we would do are regulated self-managed super fund deeds. We used to call them excluded superannuation funds. And the documents would be 300 or 400 pages in length and would set out all the rules. So we'd take the rules from the legislation and the regulations and put them in the self-managed super fund deed because it would help you as the mum and dad using these self-managed super fund deeds. And then we found changes to legislation coming so quickly, sometimes 2 or 3 times a year, that you'd have to update a regimented self-managed super fund 2 or 3 times a year. So we abandoned that. And now we do the shortest possible deed we can. So what self-managed super fund deed says, you can do whatever you want to do. You could do whatever you want to do, subject to the SIS regulations. That is one of the most powerful ways of drafting a self-managed super fund deed. Because now you don't have to update this deed every so often. As I said, maybe 5, 6, 7 years this document will have to be updated again. Permissive deeds are the modern way of drafting self-managed super funds, subject to the SIS regulations. So let's keep moving through the definitions. Now, what's this clause 3? This deed is subservient and augmented by changes to the law. So whatever happens, we try and keep your trust deed, your self-managed super fund trust deed, as up to date as possible by just merely applying when there's a compulsory activity under a regulation, under a new act, then this deed is deemed to have picked up that mandatory rule. So the deed is read down so that everything required by law, by the new regulation that came out next year, is covered by this deed. So we try and keep the document as relevant for as long a period as possible. Trustees' powers. Now, I had a student, he said, Professor Davies, why don't you just say that a trustee, either of a family trust, a unit trust, a bear trust, or a self-managed super fund, why don't you just say that the trustee has all the powers of a human being? Good point. Unfortunately, what the courts have said is that you need to state clearly what the trustee's powers are. You can't just do a blanket, whatever a human being can do, the trustee can do. And that's why page after page is given up to trustees' powers. And even now, we continue to add to this. This is one of the major areas of being added to. So when you update this document again in 5, 6, 7 years' time, you'll see these trustees' powers augmented even further. So there might be new rules on gearing up self-managed super funds, or a bank may require some other rule. We'll keep adding to the powers in this particular clause. So you can accept or reject members, how members' accounts are dealt with and their entitlements. You see, for example, does the trust allow for forfeiture, equalisation, debiting of accumulation accounts? These are unique to legal consolidated barristers and solicitors. We are specialists in this area. We sit at the table of many desktop ATO audits, hostile and otherwise, and we take notes and we come back. We make sure this self-managed super fund deed is as compliant to the Australian Taxation Office as we possibly can. There are a lot of rules. They've got a lot of secret rules at the Australian Taxation Office. We try and find out what they are and inject that protection into these trust deeds and in variations of our self-managed super fund deeds. Accept money from other funds, transfer to other funds, paying pensions. If a member goes bankrupt, we immediately restrict the amount of money that they can get. Everything's been designed to protect you as the member under all circumstances, all the circumstances we know of, the ATO has attacked. Legally disabled, payment to bankrupt. Irrespective of the above clause, while a member or beneficiary is at risk of entering into bankruptcy without reference to that member, because remember, when you go bankrupt, the trustee in bankruptcy, under the Bankruptcy Act, stands in your shoes, and whatever the trustee in bankruptcy can do, whatever you can do, they can do. So the first thing you're going to do as the trustee in bankruptcy, say, "Oh, give me all the super," if they could get away with it, or the pension's coming out, I want that money, and this is saying, no, we are not going to increase that pension. We're going to do whatever we can to keep that money there to protect our bankrupt member. Family law matters. So now you can have splitting of super. So if you're in a de facto relationship or a married relationship, same-sex relationship, and you break up, then there's an opportunity for your partner, your ex-partner, to actually grab some of your super, and these rules are designed so it doesn't destroy your self-managed super fund when that happens. Authorised investments. Now, under the Trustees Act of each state, you're only very limited to what you can actually invest in. So we've increased the amount of authorised investments, subject to the SIS regulations. It's always subject to the SIS regulations. So you can do hedging contracts, derivatives. You can buy chattels, shows in action. You could buy a Ferrari if you wanted to. But of course, under a self-managed super fund, you're not allowed to enjoy anything that you buy because it is for your retirement. So if you were to buy a Ferrari, which you legally can do, you're not allowed to look at the Ferrari. You're not allowed to keep it at home. You're not allowed to drive it. You cannot enjoy it in any way. The only exception to that is business real property. And our self-managed super fund allows you to lease out self-managed commercial property from your self-managed super fund. Limited recourse borrowing arrangements fully compliant with the bank's requirements. And each bank has their own requirements. We've adopted them all and put them in here. Death benefits, how do you deal with super at death? Delegation, power, forfeiting benefits. What happens if a trustee dies? How's it dealt with? This is an important clause, there's no partnership. One of the things we're finding of late is the insolvency practitioners are trying to argue that if you're in partnership with someone, either through a unit trust or some way of being a shareholder, they're trying to argue that there's a partnership, in which case you're jointly and severally liable. In all our deeds, you'll see no partnership clause. It's critically important. It should be in everyone's deed. If you're a lawyer watching this, you should copy that deed and put it copy that clause on no partnerships and put it into all your trust deeds, including your commercial lease agreements. So it's signed by who? It's signed only by the trustee of the self-managed super fund, in compliance with the SIS regulations. Well, that's the deed. But there's a whole lot of attachments to the deed, and let's go through them. We've had 2 minutes, we've had a covering letter, now let's have a look. So, at death, super has to be paid out. We've just learnt that, unless you've got a reversionary pension. How's it paid out? There's 3 ways that the super's paid out. Either under the terms of the trust deed, with the discretion of the trustee, or with a binding nomination. Now, the safest course of action is a binding nomination. So we document all these. So there's a non-binding nomination form, which the trustee can look at, may not even read it. There's a binding nomination expires after 3 years. I've got no idea why you want to do that. And here is here's a mouthful for you, non-lapsing death benefit binding nomination. And once you sign this, and it's with the 2 witnesses, then it doesn't matter what the trustees of your super fund want. It doesn't matter who the trustees or who controls the corporate trustee wants. They must follow the terms of this binding death benefit nomination. Now, interestingly enough, I've got on my desk at the moment a self-managed super fund prepared by a non-law firm, which is a little bit strange. And it's got in it that you can do binding death benefit nominations. It's set it in the trust deed, but only the binding death benefit nomination must be in the terms of an annexure to that non-complying self-managed super fund deed. The non-lapsing death benefit binding nomination only has 1 witness. So that poor person that's using this non-lawyer prepared self-managed super fund cannot do a binding nomination. They don't know it. Well, they'll know it when I've updated their deed, but they cannot do one, even though it's a brand new deed. So that's a binding nomination. The witnesses should then sign to say that they've signed and acknowledged the death benefit binding nomination. More information about death. And now we come to the product disclosure statement, the document that all tax lawyers said you don't need, but now all tax lawyers now want. The product disclosure statement just merely sets out what the rules are, and when you get a new member, such as yourself and your spouse, if you're doing this for yourself, then you'll give yourself a copy of this product disclosure statement. Just sets out the rules in simple English. In order to become a member of a self-managed super fund, you must make application to the self-managed super fund, and there it is there. So that's member number 1. That's member number 2. And there's a blank one, which you just merely bind with the self-managed super fund deed, and you just copy it as you go through life. And perhaps your children or your new spouse may want to become a member. Well, that's a self-managed super fund, but there was one other document here called an investment strategy. So let's have a look at that. Done the self-managed super fund, included in the price, you've got all those documents, plus you get an investment strategy. It's a locked PDF. Why is it a locked PDF? Because we don't want you to change it. There's a covering letter. All our documents have a covering letter. addressed to the trustee. So if you're an accountant, financial advisor, we are acting for your client. We carry the professional indemnity insurance. We are the lawyer acting directly for your client. You're not doing legal work. We're the ones preparing the legal documentation. And remember, only a law firm can prepare a deed. So if you grab a power of attorney, which is a deed, off the Victorian website, then you're creating a deed. You're breaking the law. And if something goes wrong with that deed, you've got no professional indemnity insurance. You should have built that self-managed super fund. You should have built that power of attorney on our law firm's website. We carry the professional indemnity insurance. We're a law firm and we're allowed to build and charge for deeds. So there's a self-managed super fund investment strategy. This is the hot to trot issue with the ATO. So when we sit at the ATO desktop audits, the first thing we're going to look at is this particular document. The self-managed super fund investment strategy, where is it? Now, this is the current letter. It's on diversification, which is a major issue for the ATO. The ATO pick up themes. One of the big issues I've got is that I'm not sure why a tax regulator, like the Australian Taxation Office, are involved in any way with a pension fund. Self-managed super funds are a pension fund. Very rarely would you ever find a tax regulator involved in it. They're just not the right people, but that's what we've been given. You get dealt your hand and you've got to play it. So this is the minute accepting the investment strategy, which you'll need to sign every year and present to your auditor. These minutes set out all the rules and regulations, and all parties, all members will sign it, including the authorised company or their officer. And here's the investment super funds. You've had the minute, and here it is. And you just want to print this out each year. All the rules and regulations. So this is exactly what the ATO are looking for. Rate of returns, investment methods and structures. You can add to this. Your accountant or advisor may want to add additional minutes to this, particularly if you've got you're all in cash or you're all in property, then the ATO may want additional information from you, maybe valuations or your views of where the market will be leading. You can add to that. Debts, cost of investing. You should review. Now someone said, one of my students said, Professor Davies, I've checked legislation. There's no requirement you actually have to sign this every 12 months. That's true. But I don't worry about what's necessarily the minimum requirements. I work out what is best practice that the ATO wants, and they want, and it looks better if you're reviewing this every 12 months. And that's your investment strategy. Now, with your assets, so you might go, say, 12 to 14%, 0 to 60% or whatever, you'll handwrite that in each year. You want it in handwritten. You want a pen, because the ATO wants to make sure that you've given thought to this and hasn't been something your accountant's just given you, or your financial advisor or your lawyer's just given you. They want it handwritten in here. So we've followed best practice. And if there's other assets, I think over time, remember these trustees go on forever. We're a family trustee. Unit trust goes only for 80 years. Well, goes forever in South Australia, but 80 years in all other jurisdictions. We might have clients owning assets off planet as we move to the Moon and Mars, all these wonderful things off planet. You can just add additional things there. So we're ready for whatever happens in this complex world that we're in. So that is a self-managed super fund deed. That's what you need to start your self-managed super fund. That's the legal requirements. Obviously, if you are talking to your accountant will have other issues about whether it's beneficial for you. Because as I said at the beginning of this training video, they're like one-day-old babies. They're really hard to look after. Now, predominantly, the people that run self-managed super funds are control freaks. They are small business owners that don't trust anyone. And that's fine. But if you're of that ilk, that you're a bit broad brush, I'm not sure the self-managed super fund's your best way of going. And I've just been instructed recently by an accountant to talk a client out of having a self-managed super fund. And that client was a little bit broad brush. These are documents and strategies that need to be put in place and watched closely and need to be protected and nurtured like one-day-old babies. I hope you've enjoyed this training video on self-managed super funds, and I wish you all the best in looking after this lovely structure. I've enjoyed mine. My wife and I have had our self-managed super fund for many years, and we've enjoyed it immensely. It's a lot of fun to look after, and I hope that you enjoy it.